Intellectual property. Defining your rights in the 21st century. Knowledge is a continuum. People have ideas, they document the ideas in books, movies, and more. Other people consume this information and then create their own new ideas and materials. As digital tools have enabled you to take digital pictures, write blogs, and design websites and share them more easily, you need to be aware of both how the law protects your intellectual content and guides you on how to use other people's content. The first and most common issue you hear about is copyright. Copyright is defined as the legal protection for a unique expression in a fixed form. Fixed form refers to the creation of a work, like a book, movie, or song, in a non-changing format, such as on a piece of paper, a film reel, or a digital sound file. Copyright cannot protect things that are not fixed, such as ideas, procedures, or concepts. So how does copyright help the creator? In the U.S., copyright is automatically granted upon creation of the work and gives the copyright creator 5 areas of protection. First, the creator controls whether someone can make copies of their work. Second, the creator controls the sale of any copies. Third, the creator controls derivative works or works that transform the original work into another format or medium. Movie adaptations of books or song parodies are examples of derivative works. Finally, the creator controls whether the work can be performed in public, as well as if the work can be displayed in public. Let's take a look at copyright in action to see what this legal protection can mean to your rights in the real world. In 2010, David Byrne of the musical group The Talking Heads sued politician Charlie Crist for using Byrne's song in Crist's political ad without his permission and without paying the proper royalties for the song. As a creator, Byrne has the right to decide who can display or perform his work and require payment for use of his music. Violation of copyright led to a lawsuit where Byrne was seeking $1 million in damages. Therefore, copyright is often a financial and legal mechanism to protect copyright owners' works. Since academic research tends to build upon other people's work, there are some exceptions to copyright. The fair use exceptions to copyright allow information consumers to use a copyrighted work without seeking copyright holders' permission if it meets 4 key criteria. First, is the use for non-commercial, non-profit, or educational purposes? Second, what is the nature of the work? For example, is the work highly creative or mostly factual? Highly creative works risk more as they are more unique than factual materials that may have the same facts existing in other forms elsewhere. Third, how much of the work are you using? A few seconds of a movie? Or the entire movie? Finally, how is your use of a resource going to impact the content owner's ability to make money off of their work? For example, say you want to scan a textbook. Your purpose is educational, and it is mostly factual information. But by scanning the entire textbook, you negatively impact the copyright holder's ability to make money by selling their book. Scanning a few pages or a chapter is generally considered a small enough piece that it would not prevent the publisher from selling the textbook, qualifying for fair use protection. The other exception is if a work is in the public domain. Sometimes public domain materials are items that have already outlived their copyright protection. The creator may also choose to waive his or her copyright so people can use and adapt the work freely. Other public domain materials include copyrighted items whose copyright has not been renewed. Documents produced by the government are also public domain materials. Just because something is on the internet does not mean it is in the public domain. To find images, music, videos, or text that do have permissions that allow for reuse, you can use the Creative Commons search. You will still need to evaluate the specific permissions of each resource to see if your use fits the content owner's permissions. The other two intellectual property laws are patent and trademark. Since copyright does not cover design or discoveries, you must file a patent to protect those ideas. For example, the design of the Monopoly game board is patented. Trademark protects names and brands, like Nike, since a name is not usually unique enough to meet copyright protection. In short, you've now learned about intellectual property rights and the specific scenarios in which you are allowed to use copyrighted works. Now, just because there are fair use protections that allow you to legally use the work, being a student comes with a separate ethical expectation, the honor code, that you cite works that you use.